Okay, let's get started. Good afternoon and welcome to today's talk. My name is Ying Xia. I'm assistant professor at this Faculty of Law and director for the Center of Chinese Studies. Today, we're very honored to have Professor Tama Osri with us. Tammy is a longtime friend and a very accomplished scholar on Chinese law and corporate governance in particular. So Tammy is an assistant professor at the Hebrew University of Jerusalem, Israel, and she got her doctoral degree from Michigan, and she also did postdoc held postdoc positions at Harvard Law School. And her publications focus on Chinese corporate governance, cross-border investment, and party-state market relations. And today's talk is entitled Law and Political Economy in China's New Era. So without further ado, Tammy, the floor is yours.
Hello, everyone. Hear me okay? It's great to be here. Thank you, Ying, for the very generous introduction. It's really wonderful for me to be here. I've been here only once, I think, at a conference in 2018, if I'm not mistaken. So it's really great to be back. I want to thank the colleagues that I see around here who came to listen in. And of course, the students. I know that you have many demanding opportunities on your time. And so I really, really thank you for the time and the interest in this talk. Our discussion today will be about law and markets during Xi Jinping's era. It is based on a few chapters in my book that you see in front of you, Law and Political Economy in China, the Role of Law in Corporate Governance and Market Growth. And the book, as the name implies, is all about the entanglement of law and politics and how such dynamics basically impacted China's growth trajectory. And the motivation behind the book is this conundrum that occupies many scholars across disciplines, scholars of China in law and in other disciplines, about the significance of law in China's quest to create markets. As we all know, China clearly does not fit to any pre-existing theories about the role of law in economic development, about first establishing legal institutions and protecting private property, then investors will come and growth will follow. Law and legal institutions in China mostly lagged actual growth, and markets often relied on substitutions. Indeed, many great scholars discuss how China deviates from this paradigm. And the literature, again, across disciplines showed how in lieu of legal institutions that are traditionally held imperative for growth, China developed substitutions that provided the needed assurances for investors and entrepreneurs. And these substitutions, again, according to the discipline you work in, goes from political connections to bureaucratic incentives, to central local dynamics, and even Confucian work ethics. Nowadays, as I'm sure you've noticed, as China's growth is challenged, these discussions come back to the fore. Many writers now, especially in foreign media, predict again China's demise. They look at the crackdown on private tech firms in China, and they argue that the lack of rule of law is to blame for these negative investor sentiments. Per these analysts, the lack of predictability and arbitrary incursions by the state prove that substitutions can basically go so far, right? That after a certain point, substitutions will lose their stream. And this is another affirmation for them that the law in China is basically weak. It's a political mirage, window dressing, and at best plays a marginal role in China's market growth. My question was, why is this skepticism about the importance of law in China, and particularly about its insignificance for economic rise, why is it so sticky? We're seeing the massive number of laws, of legal institutions, regulations in the market. We see legal constructs being advanced in China for decades, right? Many scholars that many of them belong to this institution, have written about it extensively. And still, there is this popular notion that law in China is but a political mirage, and that even if it exists mainly on the books and played very limited role, in fact, in China's market growth. So in this book, I try to push back against this sticky notion, and I join research efforts by other scholars that argue for the importance of law in China. But in the case of this book, what I argue is that formal, positive law and legal constructs are wrongly undervalued, and that law was and still is actually instrumental to China's market rise. But for us to understand exactly how and be able to fully evaluate the role played by law in China's development process, we must lose our tunnel vision. We must lose our preoccupation with rights, if you will. Perhaps a preoccupation with rights is fitting for the public law sphere, but it led us to overlook the other functions of law in the development of markets. Now, to clarify, questions about rights protections, about the quality of private enforcement are all vital, of course, to our ability to evaluate the efficacy of legal institutions. They are valuable for us to understand how and whether citizens really have their day in court. I don't mean to downplay these types of questions, but this is not the only thing that we should care about or think about when we're trying to evaluate the full scope of legal effects on market growth. We should also consider the political functions of law. So I offer instead law and political economy as an alternative framework to reconstruct the role of law in China's growth story. And the framework considers both the economic functions of law along with the political functions that the law provides for China's polity. And it shows how law and politics entwine in China's quest to create market. To establish this framework, I analyze a vast number of law and policy documents, including market-related CCP policies, plenum communiques, five-year plans and speeches, as well as practically all available market-related laws and regulations, both secondary and primary and tertiary, largely following Perry Keller's distinction from 78 until 2021. And I show how laws and legal constructs were used to allocate economic authority within the party-state system from the early days of reform until the present. And in that, I argue, the law helps structure and secure a certain desired political economic change at each stage of market development. I then take this framework and I apply it on corporate governance and the development of the public firm as my case study. And I show that the dynamics of law and political economy had real market effect on the environment within which firms operate. So for example, in the context of corporate governance, the new framework, I think, brings more clarity on many unresolved corporate governance phenomena, such as, for example, the existence of facially convergent traditional corporate governance institutions, right? China has all of the traditional institutions of corporate governance that we can imagine from other comparative systems, board of directors, supervisory commissions, independent director, and so on and so forth. It also has one of the most shareholder empowering corporate statutes in the world. And still, it is known that these traditional mechanisms only have relatively weak rights protecting functions in practice. And still, it achieved substantial economic growth. So this dilemma, I think, is solved better through law and political framework because it gives more complete and complex picture as to why these traditional mechanisms have been instituted within China's corporate governance to begin with, and why they are still there if they're not providing the economic functions that we're expecting them to provide. What else are they serving? And this is the law and political economic framework. This is just a few words about the book. But now I'd like to give you a taste by quickly getting to the weeds of the current era, in which we see what I call legalized politicization. So to contextualize the current era, let's quickly look at the trajectory of China's market development from reform and opening at the end of 78 until the present. We can identify three eras and two major shifts in market governance equilibrium, basically where political economic power have shifted from one party state hierarchy to another. So the first shift from decentralized authority to a more centralized governance is, of course, highly recognized in the political science literature, in the law literature. The second shift here, just before 2010, from a centralized state to a centralized party state, is gaining more and more attention and more recognition recently. And this is the new era, of course, that we will focus on. So if we jump to the second era here, the 1990s, until the end of the first decade of 2000, an era termed in the book as the legal modernization era, here the Chinese market had formed around features of state capitalism, right? Much of state capitalism basically owe to the existence and use of certain legal constructs, if we think about it. For example, the corporate form, right? Share ownership, pyramid holding groups, institutionalized central administrative powers, and so on. So basically, legal constructs became a backbone in the construction of China's state capitalism during the legal modernization era. But what's important to understand here is that while state capitalism during this era has brought with it substantial economic growth, and it set the stage, of course, for China's international competitiveness, it also produced some serious governance challenges and negative results. So in terms of corporate governance, for example, state capitalism resulted in entrenched and weakly monitored corporate insiders and controllers that could easily exploit public shareholders and drain corporate assets, much of which state assets at that time. Uncontrollable corporate groups, both state and private national champions, emerged in that period, with SASAC unwilling or unable to control for asset stripping, for self-dealing, and many of the illnesses of controlled ownership elsewhere. These appeared in the market full force during that era, along some more idiosyncratic problems such as local protectionism and corruption. These only grew stronger under state capitalism, and they threatened not only stability in the economy, but eventually even the legitimacy of the Communist Party and the entire system. Now, all of this happened while at the backdrop throughout China's development trajectory, as markets opened and direct ownership diluted through various diversifications and holding schemes like holding groups and so on and so forth, the party state was basically gradually losing much of its macro market controls. Now, while micro market controls, the ability to impact day-to-day decision-making, this was always a contentious issue within the party state, right? Depending to which stream within the party you belong to, macro controls was never something that the party had wished to give up upon, right? And so by macro control, I mean the ability to steer the market at large, right? This was never something that there was any intent to give up on. So in short, the mounting economic and political problems that produced by state capitalism at the turn of the era, I argue, explain much of the subsequent shift in China's political economy and the use of law. The party state needed to reassert control over markets now much more directly. It no longer trusted the state to do the job alone. And so moving to the current era, what we'll see clearly how law and legal constructs are being used in an effort to overcome the challenges brought by state capitalism to secure a new political economic equilibrium within the party-state system, one in which the party regains, reasserts through the law the levers of macro control over governing markets. Now, I call this era the legalized politicization era because, again, the CCP uses law and legal constructs to establish itself directly into the market, as we shall see in a moment. But you have a slide in front of you that actually talks about the state, because what I want to say before I move to the party, it's important to note that while the law during the current era opens up new opportunity for direct party agency in the market, we should not understand from that the state is receding from the market altogether. The evidence actually shows to the contrary. It shows that the law has been used both to establish stronger capacities of the state and stronger capacities for the party in the market. So let's start with the state level. At the state level, what we see is that law and legal constructs are being used in ways that reinforce, one, the ownership capacity of the state in the market, as well as its regulatory capacity in the market. In terms of its ownership capacity, what we're seeing is that from 2012, there is a new wind in implementing China's mixed ownership reform. Are you familiar with the mixed ownership reform, the students here? So the mixed ownership reform basically was a program that was put to use from the mid-2000s, and maybe even earlier. The idea was to mix public and private ownership in SOEs, in state-owned enterprises. That was the original idea. But from 2012, it was put to use to expand the reach of the state into the private sector as well, right? So basically, the state has been expanding its reach into the private sector through minority ownership as a minority investor through various legal constructs. So one legal construct that was used was M&A rules. If we look at the utilization of M&A rules, we see a sharp increase of M&A rules that are used in order to expand the reach of the state into the private sector. So, for example, the data shows that the number of M&A rules that addressed mixed ownership rose from an average of 3.5 rules per year between the 90s and 2013 to an average of 34.25 rules annually between 2013 to 2021. Another legal instrument that is used to expand the ownership capacity of the state in the market are various formats of direct investment contracts that promote a mechanism called special managerial shares or golden shares that basically gives the state with less than 1% ownership in a private company some specific veto rights in the companies that it invested in with respect to certain decisions, appointment of specific directors, and so on and so forth. So this type of golden share or preferred managerial shares was applied, for example, in a subsidiary of Alibaba, subsidiaries of Weibo, Douyin, Tencent. I think there is a debate, didn't happen yet, but it's in the process. So basically internet media providers, and it provided the state with some veto rights with respect to content management. Another legal instrument that was used to expand the reach of the state in terms of ownership are, of course, the creation of joint state and private funds that are tailored to invest in certain emerging industries, both domestically and overseas. So these are various legal instruments that were used to expand the ownership capacity of the state, and in doing so, to help it regain macro controls over the flow of capital to certain industrial segments. The second aspect of the use of law to strengthen the governance capacities of the state in the market is basically boosting the regulatory state through centralized powers. By regulatory state, I mean boosting the legislative, regulatory oversight and administrative enforcement functions of fewer central state institutions. And here, of course, the framework of the socialist rule of law country has been really instrumental. So these charts in front of you show political economic shifts through the lens of legal advancement. They show activism in market-related lawmaking, which I use as in the book as a proxy for the allocation of market governance powers, meaning to whom the authority to govern markets was allocated at each period. So if you look at the figure at the top that shows newly issued and revised market-related legislation and regulation at all three levels, again, primary, secondary, and tertiary rules, and you compare the current era from 2010-11, with the era that preceded it, the legal modernization era, we perhaps see an interesting surge in 2011, right? There's a slight surge here. But overall, on aggregate, it seems that regulatory activism actually is lower in the current era. So it's kind of, wait, isn't it the opposite than what she just said? She just said more regulatory activism by the state. So that's kind of not goes along with what she just said, right? But when we break it down in the lower figure, figure 5.3, that shows the same only for the primary and secondary market-related laws and regulations, we can see that while the tertiary legal activism receded, there has been a rise in secondary and primary lawmaking. So there is more serious surge that is attributed to central level regulations issued by the General Office of the State Council. So at least based on lawmaking activism, establishing the idea of rule of law governance in the market is essentially a form of advancing a hyper-centralized regulatory state. So far, this was about the governance capacity of the state vis-a-vis firms and the market. But as I mentioned, this is certainly not the only thing that was advanced through law in this period. So let's move to the perhaps more interesting stuff, which is the role or the use of law for advancing the market capacities of the party. And here, I identify three legal constructs or pathways of direct party agency in the market through which the law is used to establish the CCP, one, as a direct market regulator, two, as a corporate stakeholder, so a direct market participant, and three, formalizing the CCP market-related decision-making bodies. I'm not sure if I'll have time to attend to that, but I'll certainly speak about the first two. So let's talk about the first pathway, CCP as market regulator. So some of you might be familiar that during the 18th and 19th party congresses, so from 2012 to 2022, the CCP's involvement in the process of devising laws and regulations has increased. There have been party guidelines that require that the drafting of laws that are related to major social and economic issues will first be deliberated or debated by the Central Committee of the relevant administrative level. But, by the party committee, of course, of the relevant administrative level. But even beyond this type of background involvement in lawmaking, the CCP's direct regulatory power also increased. And here we see how this is measured by the number of jointly issued market-related CCP and State Council opinions and guiding opinions by absolute number, as well as by the annual average in each era to provide you with apples-to-apples comparison. So the increase in the CCP's assertion of direct regulatory power, I think, is pretty clear. What about the CCP as a market participant, a corporate stakeholder? I'm sure that many of you know this already, but since about 2015, we see a gradual formal retreat of familiar, conventional corporate governance institutions. Again, think about board of directors and supervising committees and independent directors. All of these things, they still exist in the corporation. But alongside them, the party has institutionalized political mechanisms into the governance of firms. And it had done so in two meaningful ways. One is by establishing a corporate party committee within an increasing number of firms. And the second is institutionalizing the disciplinary and monitoring functions of the party and streamlining it into the corporate governance. And I'll explain what that means in a moment. But in terms of corporate party committees, so since 2015, with the issuance of the SOE reform guiding opinions, corporate party committees within state-invested enterprises were reaffirmed as something that is a statutory obligation. Now, I should not note, because I'm probably going to be asked about this, there is no statutory obligation to do the same in private firms. Okay, this is about state-invested enterprises. Now, invested enterprises are not state-owned enterprises. It could be, invested as a minority investor, yeah? But there is no statutory obligation to do the same thing with private firms. So state-controlled firms at least need to have this established into their articles of association. Now, just to clarify, the charter of the CCP constitution, as well as the PRC company law, already enabled the creation of party committees within any PRC domiciled company with more than 3 party members. So the ability to establish a party committee within Chinese firms, whether these are private or state-controlled, owned by Chinese or by foreigners, this legal right was there at least since the creation of the company law. However, only in the current era, we see this coming to life with first more elaborated rules that explicate what the authorities or responsibilities of these committees should be, as well as we see more enhanced implementation of such provision. So what do I mean by more elaborated rules that explain what these committees do? So in the guiding opinions, we see that there is an explanation about what such committees are supposed to do, and it gives them oversight capacity and disciplinary functions within the firm, as well as more decision-making power and involvement. So for example, if you read through the lines, you'll see that the party committee is given authority with respect to managerial decisions about managers. So recommend about positions and assess their function and so on and so forth. There is an encouraged cross-representation of board members and supervisory committee members with the members of the party committee. And there is a default alignment of the position of the board chairman with that of the party secretary. Moreover, the party committee is given the authority to oversee, audit, and assess major corporate decisions. So basically, more defined authorities within a firm. And also, as I mentioned, more systematic implementation of this across companies, particularly in firms with meaningful state ownership, but spilling over to firms with any state ownership, even minority state ownership, and even though to a lesser degree to the private sector, including to foreign firms. Another point of interest is that these corporate party committees, one of the primary roles that they are assigned to do is basically to oversee legal compliance. So checking basically for violations of law. So in this respect, they actually integrate with the newly formalized and enhanced party inspection organs that operate outside the firm. And here, of course, I refer to the CCDI, right, the Commission for Disciplinary Inspection. So the Commission of Disciplinary Inspection, newly formalized under the National Supervision Commission, basically the Corporate Party Committee that are now being increasingly deployed within firms actually bolster or perhaps even substitute to a degree some of the governance functions that are traditionally reserved to corporate governing institutions such as the board of directors, as they also work in collaboration or in close cooperation with the CCDI. So these cooperative processes makes it easier for the disciplinary enforcement bodies to gain access to information in the corporation, detect, punish, and prevent corruption, and it has some spillover effects over corporate malfeasance more generally. Now, for those of you interested, there is an interesting illustration in the book, an explanation about how such process relies or harness in a way the corporate form and the business group structure, meaning legal constructs again. Through this example of the anti-corruption investigation and the enforcement campaign that was conducted in one of China's most important corporate group, the CNPC, China National Petroleum Corporation. So these are perhaps some potentially positive elements of these changes, right? Because I said increasing monitoring, they're substituting for functions of traditional corporate governance institutions by basically overseeing compliance with law and monitoring against corruption and spilling over for corporate malfeasance and so on and so forth. But of course, the mechanisms also enable a more easy mobilization of corporations and pyramid groups in the service of party state shifting priorities. And these can be geopolitical, it could be industrial, it could be positive priorities like more sustainable growth, it could be many things. Finally, another point of legalized politicization is the third pathway for direct CCP agency in the market, which is the semi-institutionalization or the formalization of market-related party decision-making organs. And here I basically refer to the several leading small groups with market-related authorities that had turned into commission of recent years, or super ministries in recent years. And this way, there are more formally coordinating policies from the party to the state, such as, again, we mentioned the National Supervision Commission, but also a Commission for Comprehensively Deepening Reforms, Central Financial Work Commission, and so on and so forth. So basically, all of these are legalized pathways that establish direct party agency in the market, for which I call this era a legalized politicization era. Now, how does all of this relate to the overall law and political economy framework? If we look at political economic change through the lens of law in each era, we can see how changes in the political economic power within the party state hierarchy are translated into legal authority to govern markets, and how law and legal constructs in turn help enshrine and secure such shifts, such desired shifts. Now, of course, there are many, many open questions to ask, and a lot of open questions remain, such as whether or not such legal constructs will be better able to hold party members back from spilling their intervention over to micromanagement, to microcontrol, right? We don't know how much they will interfere. What impact will this have on markets? We don't know that yet. There's some research, but we don't know that yet. There's also obvious questions about their accountability, right? If they are legalized, are they more accountable now? We have some experts in the audience that could help me answer questions about that when I'll be asked. Nonetheless, I think that in considering the overall institutional dynamics through China's development process and the ways in which law and political economy serve each other, it becomes clear that the CCP recognizes the importance of law, not only for getting the economy right, meaning getting the economic result it wanted under a socialist market economy, right? But also as an internal party state instrument for allocating powers internally within it. Now, I'll spare you the contributions of the book because of a short time. And I'll end here and very open for questions if you have. Thank you.